We now have access to documents that were previously marked confidential in the federal criminal case against Donald Trump in the Southern District of Florida, often referred to as the Mar-a-Lago document case for Trump's willful retention of national defense information, along with his obstruction of justice with co-defendants Walty Nauta and Carlos de Oliveira. These documents, previously marked as confidential, are now posted on the public docket after Donald Trump previously filed a motion to dismiss under purported due process grounds, a completely frivolous motion to dismiss filed by Donald Trump before Judge Eileen Cannon. So who knows what in the world she will do. But one of Donald Trump's tactics is to try to file these frivolous motions in order to make certain documents public on the public docket. Now, a lot of these documents that are now public are very damaging to Donald Trump when you actually read the documents. But you see, Donald Trump believes, and he's probably right in this, that his MAGA supporters are not going to read anything. They are simply going to believe whatever the right-wing media narrative is. And the right-wing media narrative being pushed right now is that the FBI authorized use of lethal force against Donald Trump in connection with the search warrant executed on Mar-a-Lago in August of 2022, when in fact what Donald Trump and the MAGA Republicans are pointing to is just a standard use of force protocol that exists in all search warrants. So I think that's why Donald Trump wanted to file this due process motion to dismiss, because he wanted to launder this disinformation, which now Marjorie Taylor Greene and all the right-wing media and Fox are pushing. Oh, the FBI was trying to assassinate Donald Trump. Look, we've actually read the documents. You'll, first and foremost, if you know anything about the law and you actually study it, you'll know this is standard protocol. It's quite literally a form that is used in all like search warrant returns and in all kind of search warrant filings like this. It's been in place since 2000, this policy. If you actually read, though, as it relates to what went down in Mar-a-Lago, you'll see that the FBI search warrant was coordinated with the Secret Service. They made sure that Donald Trump wasn't even there at all when the search took place. And it was done in a very kind of methodical way, making sure Donald Trump wasn't there when it took place. The Secret Service was tipped off and was aware of what was going down. And so all of this right-wing disinformation is absolutely relentless, and they're pushing it down. And what they're trying to also avoid is us all focusing on what's really at issue in these documents that were released. Like, for example, we now have access to photographs in connection with the search warrant executed on Mar-a-Lago that show Walty Nauta moving the boxes in June of 2022 after a May subpoena was issued to Donald Trump and the Trump Organization and to those at Mar-a-Lago for the return of the classified information after Donald Trump repeatedly refused to turn over the classified information, the sensitive information, the war plans, our nuclear secrets, and Trump continued to lie and either claim it was turned over or refuse to comply. We literally see, look, you could see Walty Nauta in the surveillance footage that the DOJ has moving the boxes to try to hide and conceal it. Some of the other documents that were released was a March 2023 order by the Washington, D.C. presiding judge of criminal grand juries. At the time, her name was Federal Judge Beryl Howell. You'll recall that we reported a lot on her there. And in her order, she made some, very powerful findings against Donald Trump and the crimes that he committed, the crimes that were sufficiently established such that Trump's lawyers couldn't assert a attorney-client privilege or work product privilege because a crime fraud exception applied. Here we have an 89-page order from Judge Beryl Howell from March 2023, denying Trump's lawyers' claim of attorney-client privilege on the basis of the crime fraud exception. Here's what Judge Beryl Howell ruled. The government has sufficiently demonstrated all three elements of this obstruction statute by providing evidence that the former president intentionally concealed the existence of additional documents bearing classification markings, knowing that such deception would result in providing unknowingly false representation to the government. As a result, the former president's actions were intended to impede the FBI's investigation of his unlawful retention of classified documents, establishing a prima facie violation of Section 1519, which is the obstruction statute. Also, we learn from these documents that were now made public, if we actually, care about facts and information, that even after the search warrant was executed on Mar-a-Lago in August of 2022, Donald Trump still had classified information and classified documents in his bedroom and in other locations, about 6 other additional classified documents that were found. Here's what is stated. Notably, no excuse is provided as to how the former president can miss the classified marked documents found in his own bedroom at Mar-a-Lago. Instead, the government has provided evidence to demonstrate the full arc of criminal violations already concluded more than 6 months before the search of Mar-a-Lago, when the evidence demonstrates that the former president intentionally failed to provide all of the classified information in his possession to the government with the June 3rd, 2023 certification. So 6 additional classified documents Donald Trump's lawyer had to then turn over to the Department of Justice back in 2022 after the search. Remarkably, the report regarding the Mar-a-Lago search conducted on December 15, 16, 2023 uncovered 4 more responsive records. 4 responsive records found at Mar-a-Lago on December 15 to 16, 2022. The certification misleadingly refers to these documents as, this is what Judge Beryl Howell was saying, low-level ministerial documents without any explicit mention whether they had classification markings, indicating only that one document includes an explanation that it was no longer deemed classified if not connected to the attachment, and this document had no attachment. To be clear, the 4 documents were responsive to the May 2022 subpoena. On or about December 15, 2022, the former president's counsel informed the government that a box containing 4 documents or partial documents totaling 6 pages with classification markings were found in a closet of the office designated space at Mar-a-Lago, and those documents contain markings of the secret level. The office provided the entire box in which the 4 responsive records were located to the FBI on approximately January 5th, 2023. So 6 more pages were turned over after the search was done in August of 2022 on January 5th, 2023. That was still not the end of the production of responsive records. In complying with the subpoena to produce that box, the office also provided the FBI with 2 additional documents responsive to the May 2022 subpoena, one empty folder and another mostly empty folder marked classified evening summary that were found in the former president's bedroom. Then Judge Beryl Howell, back on March of 2023, reached the following conclusion. Based on the foregoing analysis, the crime fraud exception entirely vitiates the attorney-client and work product privilege that has invoked to withhold testimony regarding the 6 topics identified by the government. The exception vitiates any privilege intended to be invoked by the former president as to redacted who the person is on the first 5 topics. Further, 58 of the documents over which so-and-so has claimed privilege have been pierced by the crime fraud exception. If you take a look at the law enforcement operations order regarding the search warrant, now this is the part that MAGA world is talking about, Marjorie Taylor Greene and others. If you go and look at the list where it says law enforcement operations, overall plan and summary, let's just take a look at what the plan and summary was in connection with the search warrant that was executed. It says the DOJ and FBI will contact the former president's retained counsel to notify him of the search warrant and request collaboration and assistance. After a reasonable time period, the FBI will execute the search warrant with the case team and the filter team and a Mar-a-Lago representative with United States Secret Service. The execution will require coordination with the United States Secret Service and may include coordination with Mar-a-Lago guest services to ensure a fulsome understanding of the spaces occupied as designated in the search warrant. And then it goes through the processes of what's going down and when it's going down. And then it just has the standard policy for the use of deadly force, which is a standard policy relating to all search warrants. That is what Donald Trump and his team is now kind of seizing on. Here's Christina Bobb, who's made her photo on Twitter, now X, her mugshot that was just taken in Arizona. She goes, "What the F? They were all prepared to kill me. A few dozen FBI agents versus me. They were ready to kill me. What in the world happened to the United States of America?" And then they're citing the New York Post, who goes, "FBI was authorized to use deadly force in classified documents case." As our editor-in-chief, Ron Filipkowski, writes, "She was there. All they did was ask her to stand outside. If they wanted to kill Looney Tunes here, they would have. They did nothing." There's actually a rare statement that was issued by the FBI because of all the disinformation being put out by MAGA. FBI issues rare statement directly responding to this attack from Trump and his allies, says standard protocol was followed. No one ordered additional steps to be taken, and there was no departure from the norm in this matter. Quote, "The FBI followed standard protocol in the search, as we do for all search warrants, which includes a standard policy statement limiting the use of deadly force. No one ordered additional steps to be taken, and there was no departure from the norm in this matter." But MAGA Republicans won't let the truth get in the way of their lie. Marjorie Taylor Greene's now saying, "I made sure that he knew," referring to Donald Trump, "the Biden DOJ and FBI were planning to assassinate President Trump and gave the green light. Does everyone get it yet? What are Republicans going to do about it? I tried to oust our speaker who funded Biden's DOJ and FBI, but Democrats stopped it." And here Trump goes, "Wow, I just came out of the Biden witch hunt trial in Manhattan, the icebox, and was shown reports that crooked Joe Biden's DOJ and their illegal and unconstitutional raid of Mar-a-Lago authorized the FBI to use deadly lethal force. Now we know for sure that Joe Biden is a serious threat to democracy. He is mentally unfit to hold office. 25th Amendment, exclamation point. As reporter Brianna Morello says, "I did some digging into the deadly force verbiage that was used in court documents regarding Trump's classified documents case. Since 2000, every FBI operation plan has had a deadly force policy section pre-filled in. All federal agents are authorized to use deadly force in accordance with its policy. I'm told this is nothing unique, and it is pretty standard." As our editor-in-chief, Ron Filipkowski, writes, "Trump, the crazies, and the monetized clickbaiters are hyperventilating over the standard search warrant language that they claim meant the DOJ FBI planned to assassinate Trump, except they knew that Trump and Secret Service weren't there. But don't let me interrupt the crazy." Sarah Isger says, "Anytime the FBI takes an adversarial action, like executing a search warrant, there is a deadly force policy. If there is danger to you or the public and there's no alternative, you are authorized to use deadly force. This is standard policy." As John Goldberg from the Dispatch writes about Marjorie Taylor Greene's post, "This is wildly irresponsible, even for professional trolls like Marjorie Taylor Greene. FBI knew that Trump wasn't there. It was all coordinated with the Secret Service in advance. This is deeply dangerous BS." And so when you look at this document, you go, well, why would Trump want this released with all of this damaging information about the obstruction, showing Walty Nauta taking the boxes? Why would Donald Trump file this due process frivolous motion that would go nowhere? And even if it was granted by Donald Trump's judge of choice, Donald Trump's appointed Judge Eileen Cannon, even if she granted the motion, it would get overturned by the 11th Circuit. Trump wanted that document out to coordinate Biden's a threat, he's trying to kill me, so that they could play the victim and whine about it. Always the victim, always lies. Perpetual victims, perpetual whiners. That's who they are. with everything that they do. It's important that we use critical thinking, that we read these filings like we do together so you can see for yourself. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers together. Thanks for watching. Have a good one.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.